entering an automobile. This one in 2003 out of Cobb County for cruelty to children in the first degree. There was one in 1993 out of Henry County for robbery. One in 1986 for robbery.
Enjoy the video. Hit the like button.
Okay. We're going to get on the record. This is 25 PI 009708, which is the state versus Tyrone Butler. Mr. Butler is now in court with his lawyer, Mr. Alviz. Mr. Abadi, you handling this for the state? Okay. Ms. Hall had been here. You dismissed her?
Yeah.
Okay. All right. So we've got a representative from both sides. And Mr. Butler, all we're doing today is sorting out bond. So your lawyer is going to articulate why you ought to have a bond and what that should look like. Mr. Abadi is going to share with me maybe a little bit about what he understands the case to be about, and the state's position on bond. If there are any family members of oops, that's the wrong page. Mr. Holmes, I may hear from them. I will hear from them if they want to be heard. And then I'll wrap up again with your attorney having the last word as to what we're going to do. And I'll let you know. As long as your case is unindicted, questions about bond will stay with me. Once it is indicted, it's going to be assigned to some judge, and that'll be the judge who's dealing with bond and everything else with the case. All right? Counselor, when you're ready.
Of course, Judge. Judge, my client, Mr. Butler, is 62 years old, born and raised here in the state of Georgia, Judge. He lives here at the address listed on the booking sheet with his daughter. He does have his entire family here. His sisters, his brothers, his wife, whom he's been legally married to for the past 37 years, and his 2 adult children. His daughter mentioned earlier, 36, and his son, who's 32.
He lives with his daughter. His wife does not live in that household?
My apologies, Judge. That is the daughter's house. So him and his wife both live there with his daughter, Judge. And again, they've been married for 37 years. He did reach the 11th grade at Bass High School. However, he did attain his GED. He was gainfully employed up until his most recent incarceration, Judge, with Cater Blessing. That is his wife's business, of which has been in perpetual business for the past 20 years.
It's a catering company?
Yes, Judge, that's correct. And with that being said, I know today is only about bond and not related to the circumstances of the matter, Judge. I would just...
They're not completely divorced from each other.
Correct.
But I don't think have you had a preliminary hearing yet?
No.
So you know precious little about the case.
Correct, Judge.
And I appreciate that fact.
And with that being said, I would just like to point out to the court that at this point in time, my client is innocent until proven guilty, and he will leave this courtroom presumed innocent, Judge. With all that being said, I would ask for a bond to not exceed a total amount of $100,000. Unfortunately, there's no amount that can be put on the back of the loss of life, Judge. However, I believe given the length of my client's ties to the community, the fact that he has a majority of his family living here in the state of Georgia, that he does have an address to which he could return to, that he does have employment to which he could return to, I base that number off of that set of circumstances that I put forth to the court today, Judge.
Sure, and it's not an insubstantial amount. It's a big number.
Unfortunately, though, no amount of money can be placed upon a life, Judge. Again, with that being said, though, I would ask for a bond to not exceed $100,000.
Okay, appreciate it. Before I hear from Mr. Abadi, Ms. Jackson, did you have a chance to look up any criminal history for Mr. Butler?
Yes, Your Honor.
And what did you find?
23 cycles. The last arrest was May the 29th, 2018 out of Cobb County for entering an automobile and battery and 2 counts of aggravated battery and theft by taking and financial or transaction card theft and financial transaction card fraud, and an additional case of theft by taking. He does appear to be on probation out of Cobb County for 2 counts of aggravated battery. That disposition date was May the 1st, 2019, and the term is for 7 years. There are prior felony convictions, one in 2011 out of Cobb County for entering an automobile and theft by taking and possession of tools for commission of a crime and financial transaction card theft and 2 counts of theft by receiving stolen property. There was one in 2008 out of Cobb County for possession of tools for commission of a crime and entering an automobile. It's one in 2003 out of Cobb County for cruelty to children in the 1st degree. There was one in 1993 out of Henry County for robbery, one in 1986 for robbery, one in 1984 for aggravated assault, and one in 1981 for burglary. And there are misdemeanor convictions, one in 2000.
I'm good. The felony list was enough to get me up to speed. I appreciate all that.
Yes, sir.
Thank you, ma'am. Mr. Body.
Yes, Judge. The state respectfully requests you deny defense counsel's motion for bond. You just heard the defendant's criminal history. So I would submit to the court that he is a significant risk of committing felonies pending trial, as he is a 9-time convicted felon. Not only does he have a hold out of Cobb County for his probation violation, but he also has a parole hold for a parole warrant that existed prior to this incident on 11/26 of this year. I would submit to the court that he is additionally a significant threat or danger to the people in the community in it. This entire incident is caught on video where the victim is waiting outside of the address, which is 1271 Marietta Boulevard, Northwest here in Atlanta, over on the west side, I guess. And it's Vivid nightclub. Victim was waiting for an Uber. He had some drinks that evening. He ended up missing his Uber and remained seated in front of the club. The defendant walks by the victim and they have some words. They separate, and then the victim is in the parking lot. The defendant reapproaches them after putting his hood up, and he bumps his shoulder in an attempt to get the money that was in his pocket. There's a physical altercation after the defendant bumps the victim, and then the defendant pulls out a knife and stabs the victim several times. At that point, he takes the victim's money and phone that were on the parking lot floor, and the defendant then walks away. The victim, in an attempt to get his items back, begins to walk towards the defendant, who then turns around, and before anything happens, the victim actually falls onto the pavement, and the defendant walks over him and then stabs him again. At that point, he then leaves and takes off. There is obviously the detective is able to quickly get the video back the very next day, or I guess the same day. So, because this happened in the early morning hours of the 26th, the detective, because it's so high definition, is able to recognize the defendant as walking in the same area. At that point, places him under arrest. Defendant gives him a fake name and date of birth, as well as a fake, it's a real ID, but it wasn't his ID. And at that point, he's placed under arrest. He makes a statement to the police. He admits that he did everything that I just described, said he did it in self-defense. And the money that was actually taken off the defendant's person, as well as the knife that he used to likely stab the victim, are collected into evidence. The money has blood all over it, showing that the money was likely the victim's in this case. It's all been submitted to the GBI for testing. Based upon all of that, the state would respectfully request you deny the defendant's request for bond today.
Okay. Mr. Alves, I know some of that may be brand new to you. Obviously, it's all new to me. All I knew was that Mr. Holmes had been stabbed. So there's some context there presented from the state's perspective. And also front and center is the fact that your client enjoys the presumption of innocence. Right next to it, front and center, is on probation when this happened, hold out of Cobb, parole hold. So there's some wrinkles in there for him. But before I ask you to respond, if you want to respond at all, I forgot to close the loop and ask Mr. Bate if anyone from Mr. Holmes's family wanted to be heard, or if you had words to share on their behalf. I didn't mean to skip over that.
And I apologize too. The victim's sister, Miss Kimberly Holmes, wanted a very brief statement to the court.
Okay. Ms. Holmes, if you'll come on up and follow Deputy Gordon's direction as to where to walk and stand.
Hi, my name is Kimberly Holmes, KIMBERLY HOLMES, the sister of Evan Holmes. Due to the violent nature of this heinous crime, I think bond shouldn't even be an option. The defendant has a lengthy criminal history. He has zero ties to the community, so I believe he is a flight risk. Our family has been absolutely devastated by the loss of my brother, and again, I believe this defendant should not have a bond. Thank you.
Thank you for being here. I'm sorry for your family's loss.
Thank you.
Anything else, Mr. Body?
No.
Okay. Mr. Alves.
Thank you, Judge. I certainly don't understand the pain or the difficulty that the victim's family is going through at this point in time, and not to minimize it in any way, shape, or form. That's not what this is about. However, Judge, I understand that the court at this point in time has heard from myself, the state, and from a representative of the victim's family. With that being said, Judge, I still would ask for a bond to be set in this matter. I stand by the argument that I made earlier, Judge.
Okay. I appreciate that. Mr. Butler, it is early in the process. It will be a lengthy process wherever it ends up. But your lawyers, and you may end up having more than one because this case may transition from Mr. Alves to a lawyer if and when the case gets indicted. It will be a colleague of his. They will learn more about the case and will be in a better position to provide more context to what this is all about. But based on what I've heard about your more recent criminal history, it's not great that in 1986 you had a robbery conviction, but I appreciate that was 40 years ago, and that's not who you are today. But you are on active probation for an aggravated battery ×2. That's a crime of violence. You've got a parole hold, and those are all situations that say to me that bond is inappropriate till those other things are sorted out at a minimum. And not until your lawyer or lawyers have an opportunity to watch some of this video, et cetera. The proffer of facts, of evidence from Mr. Abadi makes me worry about your safety and others, given the situation you got involved with and the outcome for Mr. Holmes. And then the criminal history piece makes me concerned that you might not stay out of trouble while you were on bond. I do see that you have connections to the community. You're a Georgia native. Your wife has a 20-year business that's based not in Fulton, but it's local enough. It's not based in Las Vegas. So there are ties there, but there are these countervailing influences of what you've been up to in the last few years and some of what we just heard from the prosecutor. So at this point, I'm going to deny bond. But as I told you at the outset, unless and until you're indicted, Mr. Alves knows he can come back here after he's received new information, different information. If there's any change in circumstances, we ought to revisit this. But as long as things stay as they are, with not one but two holds, et cetera, I'm going to keep you where you are and let your lawyer start doing the work that needs to be done in your defense. Thank you.
Thank you, Judge.